What does proof beyond a reasonable doubt mean? Are you curious? Well, keep watching because in this video, I'm going to explain what reasonable doubt means. My name is Jamahl Kersey and I'm a criminal defense and immigration attorney in San Diego. In a criminal case, the prosecutor has the burden of proving the defendant is guilty beyond a reasonable doubt. The defendant has no obligation to prove anything at all. The standard of proof is proof beyond a reasonable doubt. This is the highest standard under the law, which makes sense because we're talking about the government's ability to take away a person's freedom, so we want to make sure we get it right. In illustrating reasonable doubt, it can help to compare reasonable doubt to other standards of proof. Probable cause is the lowest standard of proof. Probable cause is simply reasonable grounds. Police officers merely need probable cause or reason to believe a crime has been committed in order to make an arrest. Next, we have a preponderance of the evidence. This is the standard employed in civil cases such as car accidents and business disputes. A preponderance of the evidence just means more likely than not. The plaintiff in a civil case needs only tip the scale 51-49 in order to win their case. Up next is clear and convincing evidence. This is a higher standard than a preponderance of the evidence. In California, this is a standard that must be met in order for children to be taken away from their parents. So naturally, because more is at stake, there should be a higher standard. Last comes proof beyond a reasonable doubt. As I mentioned, this is the highest standard in the law, and rightfully so. We're not just talking about a dispute over money or negligence. This is the government arguing that a person's freedom should be taken away or their liberty otherwise restricted. As such, prosecutors are held to a higher standard when arguing that someone is guilty in a criminal case. At the end of a jury trial, the judge reads some instructions to the jury to assist them in their deliberations. Here's some of the language from the instruction on reasonable doubt. The fact that a criminal charge has been filed against the defendant is not evidence that that charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. An abiding conviction are the key words here. As defense attorneys, we want to impress upon the jury that unless they have an abiding conviction that the charge is true, then there's reasonable doubt and they must find our client not guilty. It's simply not enough that you don't like my client, that you don't like what he's alleged to have done, that you think he might be guilty, or even that you think he's probably guilty. Unless the people have proved guilt beyond a reasonable doubt, you must find not guilty. I hope my explanation of reasonable doubt was informative. If you're watching this video, it may be because you've been charged with a crime and you're curious as to what your rights are. And if this is the case, I invite you to give us a call at 619-399-3662. We'd be happy to give you a free consultation and explain your rights to you. If you like this video, please hit subscribe, like it, and share it as well. I want to thank you so much for watching. Until next time.